Hello, I'm Lisa Gilday-Moraga and I specialise in family law. One of the most common questions I'm asked is, how do I reach an agreement with my former partner regarding our children and our property? People are often surprised to discover that there are actually various pathways to creating such an agreement and that they have a number of options available to them. The path that is eventually chosen is very important for the individual and their family, and careful consideration needs to be given to which option is going to be best for you and your family. First, let's look at what formal agreements you need to have. Once you have an agreement in principle about how property is to be divided, you will need to make a final and binding agreement. This can be done by obtaining a consent order, which is issued by the court. But you don't actually have to go to court to get those orders, and once they are issued, except in exceptional situations, your former partner cannot later seek to vary or challenge the orders. There are a number of options for agreeing arrangements for your children. You don't have to have any formal legal agreement, but an informal agreement or a parenting plan can be helpful for ensuring that you and your former partner have thought about and agreed the important details for your children. The ways in which you can reach agreement are varied. You could reach an agreement in principle directly with your former partner. I strongly recommend, if you choose this course, that you first get some legal advice about your rights and entitlements concerning property division and what you could expect at law concerning living arrangements for your children. It's not always possible, of course, following separation to have an open discussion, but there are other options that are open to you. These include appointing a lawyer to negotiate an agreement for you, or going through a mediation or a collaborative law process involving lawyers. If agreement can't be reached, then taking a court action may become necessary, although I do consider that a court action should be a very last resort. As part of any decision whether to go to court, you will need advice about a number of factors, such as the estimated costs involved and the likely outcome of a court action. The path that you choose to reach agreement is important for a number of reasons, including how successfully you are able to interact with your former partner in the future. Your marriage or partnership may be at an end, but maintaining open lines of communication can be very important and helpful, especially where children are involved. I want to remind you that this is actually just a brief outline of the ways to document a legally binding agreement and the different options open to achieve agreement. I encourage you to obtain comprehensive legal advice about your situation and to start that process early towards reaching agreement with your former partner. I'm Lisa Gilday-Moraga. If you have any questions, I'm happy to speak with you over the phone on a complimentary basis during the initial call. I can also meet with you in person or speak over the phone if you prefer for a fixed-rate initial consultation, where you will receive more comprehensive advice tailored to your personal circumstances. Please feel free to contact me at LGM Family Law.